Good evening. Welcome to today's lecture at the Käte Hamburger Center, Law is Culture. Tonight, Professor Francesca Caroccia is going to address the fundamental question of our center. That is, how the law is managing cultural conflicts in the age of globalization. One of its important mechanisms to do so is the public order, or ordre public, as it is called in many countries and also in Germany. Most legal systems have provisions in their private law, that is, their civil codes, that contain a clause prohibiting violations of the public order, the public policy, or ordre public. Such clauses exist as limits both for private ordering of individuals in contracts, as a limit to private autonomy, contractual freedom, but also they exist as limits in the application of foreign law. Some values and norms are deemed so fundamental, so inherently just and evidently embedded in the specific culture that they do not seem to be acceptable in this particular country that somebody is going to violate them. The public order clause, or exception as it is also called, therefore provides for a possibility to enforce such fundamental norms or values, or to ward off results of private ordering, contracting, or the application of foreign law that would actually clash with those fundamental norms and values. These clauses thus draw the borderline when it comes to clashes of different cultures, which are becoming increasingly frequent in our globalized world. The exciting question, therefore, is how public policy or public order is defined. It is the judges who interpret these clauses. What do they refer to when they rule that a particular contract is in violation of public policy? Or that a foreign law, which according to the conflict of law rules is applicable in the particular case, should not be applied because it is incompatible with public order? What is so fundamental to the internal forum? Does this change over time? Are there any differences in the treatment of these cultural conflicts via public order from one legal system to another? Tonight, in her talk on public order and private law, Francesca Caroccia is offering us an insight into this topic from the Italian legal perspective.
Yeah.
But first, I have the pleasure to introduce Professor Caroccia from Università dell'Aquila. Francesca Caroccia studied law at the University La Sapienza in Rome. In 2004, she obtained her doctoral degree at the Faculty of Law of the University of Molise. Subsequently, she has been practicing law and acting inter alia as assistant of former President Amato in the Italian Parliament, consulting in bioethics and European private law, and later as legal advisor to the Italian Minister of the Interior. Since 2008, Francesca is adjunct professor for private law at the Università dell'Aquila, where she is teaching private law, commercial law, comparative law, as well as legal theory. In 2009 and 2015, Francesca was visiting professor at the University of Toulouse, where she taught on the master program International Law and Competition Law. And she is member of several editorial boards, just to mention a few, the editorial board of the Revue Droit et Société, and also a member of the editorial board of the collection Jus Europeum e Sistemi Italo-Francofoni. Professor Caroccia has published extensively in various fields of private law, especially in contract law and also in commercial law, comparative law, and legal methodology. Since May, we have the pleasure to have her back here at the center, where she is continuing her work that she began in 2013 when she already stayed with us as a fellow. Francesca, we are very much looking forward to your presentation.
It's my pleasure. So, thank you and good evening. I'm sorry for my voice, but I promise I will not take too much time, but first of all, let me express my warmest thanks to Nina and to Werner for inviting me for the second time in this beautiful place. The time I live in the colleague is always very precious for me, from both professional and personal point of view. And also my thanks to all of you and to all people who work at the center. They are my point of reference every morning when I arrive at my office, when my bed is broken, my shower is cold, and thank you for helping me every day and allowing me to work serenely. So let's start. As you know, the title of my research project is Public Order and Private Law Managing Cultural Conflicts in the Age of Globalization. For the moment, and very quickly, I could say I investigate the use of the public policy clause in private law, showing that this clause is currently applied by judges in order to solve cultural conflicts in national legal systems, particularly when law does not offer prompt or good solution. I am very grateful for this opportunity to discuss a matter in which I have long been interested, and I have few certainties and a lot of questions for you. I will try to be as clear as possible, and I hope you will help me to find the right itinerary. So, as I said in our last fellow meeting, my current research on public order is a part of a wider work about general clauses. And general clauses are a technique of regulation characterized by producing rules which have a high degree of vagueness. Their ambivalent nature is constantly emphasized by legal scholars. On the one hand, they are an opportunity as they grant the legal system the necessary flexibility, answering the dialogue between norms and facts, law and society. On the other hand, they represent a problem as they ask judges not only for applied law, but also for filling in the meaning of a norm. The main problem is to fix the discretionary level admitted in every legal system, finding solution in order to reduce the risk of arbitrariness and politicization of the system. In national context, with particular reference to civil law countries, the much shared solution, I can say, is a juridification of social parameters, connecting or transforming social parameters or social norms to legal norms, in particular to constitutional rules. However, in the age of globalization, it is necessary to enlarge the national perspective, taking into account the effects of the globalization on the use and signification of general clauses. My aim is to analyze what happens when the context continuously changes and the interpreter should manage strong cultural conflicts, deep moral conviction, but he has no longer traditional point of references. In the second phase of my research, I will try to take up this challenge, analyzing the public policy concrete functioning. Among different general clauses, I have chosen public order because, in my opinion, it is one of the cases in which the political role of judges is most evident, assuming that in the hermeneutical activity, the level of politicization essentially depends on the judge's freedom to attach meanings to legal norms. It's just an assumption. Huh? In this respect, probably it is possible to introduce a sort of distinction between general clauses having a more technical meaning and general clauses having a more political meaning. In the first group, the creative activity of judges is present, but it is in some way reduced by the intervention of technical experts, for example, in order to define the best interest of the child, the judge can ask to a psychologist. On the contrary, in the second group, the creative activity of the judge is quite completely free. He can decide without support of an expert. As a general clause, public policy has a very vague meaning, strictly linked with the historical, cultural, and social context. A sentence of the European Court of Justice strictly connects the meaning of public policy with the territory. The court affirmed that public policy was a territorial concept. Such cultural dimension and the impossibility to exactly define this clause was pointed out by all legal scholars interested in this topic and are reflected in the impossibility of its immediate translation in other languages, or impossibility or difficulty at least. Just make a small clarification. Until now, I used the expression public order, but with quotation marks, as a provisory and inadequate translation of the Italian clause ordine pubblico and the French equivalent ordre public. Such expression could have at least three different meanings corresponding to three different English concepts. The terms ordre public and or public policy will be hereinafter used instead of public order, with the caveat that these expressions are not exactly coincident. And moreover, the same expression is absent in the German Civil Code, where the Bürgerliches Gesetzbuch only knows good faith, treu im Glauben, und good morals, good sitten, as Werner remember in our last fellow meetings, but Germany law knows the use of public order as the most appropriate, at least at the most appropriate, as the most appropriate expression in an international context concerning conflict of law. Obviously, these translation problems are strictly linked to the history and the cultural context in which the same clause was conceived. Probably one of the most relevant elements to take in account is to explain this difference is the different national approach on the question of the relationship among state, political power, private autonomy, and freedom of judges. But it would be too long to explain all that this evening, and we will have the time, I hope, next months. Notwithstanding this uncertainty, it is possible at least to distinguish between two different ways of understanding ordine pubblico. That is, ordine pubblico materiale, in English is public order, properly, and ordine pubblico ideale, in English public policy or ordre public, in an international, more international context. In the first sense, public order depicts a situation of material peace, that is, the absence of disorder caused by human or natural events, a police enforced order. In the second sense, public policy is the totality of peremptory principles on which a given legal order is based. The public policy rules are established to protect public interests and affect both family and economic relations. Any declaration that a relationship of any kind is contrary to public policy is sufficient to invalidate it. Its content is not predefined, but it is entrusted to the continuous dialogue between normative datum and interpretation, as Nina said. I will consider public policy in its second meaning, and I will conduct my analysis from the point of view of the private law. In private law, public policy essentially plays two roles. From the internal point of view, it essentially marks the limit of private autonomy against public power. From the external point of view, it essentially marks the limit of the national legal system against foreign rule. Legal scholars emphasize the difference between these two meanings. According to this traditional approach, in the internal private law, public policy indicates the imperative character of some juridical norms from which the parties cannot derogate through their legal activity. While in the international private law, ordre public holds back the enforcement of a foreign law. They should have different function. As I said, public policy is aimed to express the limit of private autonomy, while ordre public has the role to fix the limit of the efficacy of foreign laws and legal institutions in the territory of the foreign state. And they also should have different areas of implementation. However, it could be interesting to note that in both of its meaning, the public policy clause is the expression of a defined and predetermined political project. It is the result of a certain way of conceiving society, citizen relationships, power, and private autonomy. From both internal and external perspective, public policy expresses a given order that is the political and cultural identity of each legal system or legal order. Some rapid remarks in order to clarify this point. From the internal point of view, the ordre public clause, already used in criminal law since at least 17th century, more or less, was inserted for the first time in a civil code only in 1804 in the French civil code by Napoleone Bonaparte. And that choice has been explained not simply as an effort to fix the respective borders between valid and invalid, lawful and unlawful, but in the French Civil Code, ordre public also had the specific function of preserving the new legal order conceived by Napoleon, the new political project. Through contract law and property discipline, Napoleon draws a new social equilibrium, imposes a new concept of citizen relationships, and wants to protect his project against other powers. The same strong political attitude was also present, for example, when fascism approved the Italian Civil Code in 1942, where in our Civil Code the ordine publico was inserted to play a key role. And so after the end of the dictatorship, after only 3 years, 2 or 3 years, not surprisingly, its use by the jurisprudence in Italy was very, very rare. In other words, in the traditional perspective, the public policy clause protects legal order through the definition of the exact extension of private autonomy area, and it showed what individuals and private parties can do and what they can do. From this perspective, it is correct to affirm that public policy marked the limit of the private autonomy in relation to the public power, in relation to the state. From the external point of view, from the other point of view, as I said, ordre public is the limit of validity of legal institution. National judge can recognize the efficacy of a foreign legal institution, marriage, will, contract, only if that foreign institution is not contrary to public policy. In other words, courts do not allow the enforcement of foreign norms or foreign institutions although these norms are competent according to the conflict rules when foreign solutions violate on public policy. Moreover, from both internal and the external perspective, public policy is not simply a synonymous of public law, not merely the assembly of the imperative norms of a particular law system. As I said, public policy extends beyond the positivist dimension, which specifically characterizes the law, particularly in civil law countries. In the Italian Civil Code, contract can be avoided because it is contrary to public policy or to law or to good morals. And at the same time, for example, acts concerning human body shall not be contrary to public policy or to law or to good morals. So it's always a public policy or to law. So public policy is something different from the law. It is not only the totality of positive and imperative laws, but a most comprehensive set of values, principles, and rules expressing the political project which is at the base of a given legal orders and particular cultural identities. Hence, the opinion is confirmed that the traditional function of both internal and international public policy is to preserve the cultural identity of a given legal system, recognizing and protecting a specific both political and legal order. What about all that in concrete cases? I will try to demonstrate in the second part of my speech the necessity of conceiving a new public order notion through a very rapid case analysis. In the first case, there was a man, Mr. Franzi, and he was ordered by the Supreme Court of the Commonwealth of the Bahamas to pay a debt owed to a foreign society. The name of the society was Paradise Enterprise. The loan was provided to finance his gambling debts, gambling games, in the Bahamas. And therefore, the foreign corporation, the Paradise Enterprise, asked the Court of Appeal of Rome to obtain the recognition of the efficacy of the judgment. And the Italian Court of Appeal refused to recognize the Bahamian judgment because it was contrary to Italian public order. The Court of Appeal argues that the debt was functionally linked with gambling, and gambling is strictly prohibited in Italy. One of the consequences is that creditor cannot enforce gambling debts. Creditor has no action to obtain the payment of the debt. But this was the decision of the Court of Appeal. 4 years later, the Italian Supreme Court reviewed the decision of the Court of Appeal. Following the reasoning of the Supreme Court, the notion of public policy adopted by the Court of Appeal was not consistent with both Italian internal general principles, not law, but principles, and international public policy. In particular, Supreme Court argues that the public policy notion is evolving, and traditional definition of public order as the set of internal mandatory rules and binding provisions can no longer be accepted. Hence, public order notion cannot be strictly linked with national legal orders. It must be consistent with international principles and values and must be evaluated in the light of the axiological system, which includes international sources of law. Moreover, courts don't have to establish if in abstract and general terms foreign legal institution or foreign rule are contrary to general principles and values. Instead, they have to evaluate only the concrete, limited and specific effect of that foreign institution and judgments. In the concrete and specific case is the theory called the ordre public atténué theory. In this regard, the Italian Supreme Court expressly quotes a statement of the European Court of Justice, and in the sentence of the European Court of Justice, the court affirmed that member states are free to define their internal discipline of gambling, but taking into account that cultural, moral, religious differences are very deep from state to state, especially in this matter. However, national restriction must respect the principle of proportionality. In the light of this last mentioned decision, the Italian Supreme Court argues that gambling is not negative in itself, but as an instrument for infiltration of criminal organization. Therefore, gambling cannot be considered contrary to public policy, and Mr. Franzi was ordered to pay his debt to the Paradise Enterprise. Some rapid remarks. First, Italian law, I say, prohibits gambling and doesn't provide action for gambling debts. Such provision is very clear in Italy, no? There's no doubt. However, the Supreme Court establishes that gambling debts must be paid, introducing a judicial norm that is contrary to the internal positive law. This could mean that jurisprudence could create a norm against the legislator's will. And second, the Italian Supreme Court goes beyond the internal concept of ordine pubblico and adopts a unique notion of public policy that transcends national borders and is totally identified with international principles and values. But please note that this case concerns obligation law. What happens when the case is linked with deeper cultural codes, religious beliefs, or collective sense of identity of a given country? The use of public policy and the attitude of the court establishing its content are still the same, for example, if it comes to some aspect of family law or human body? Second case. The second case is a judgment related to bigamy. In Mogadishu, a Somali woman had married an Italian man. After the death of her husband, she claimed her portion of his inheritance. However, the husband had already had a first marriage in Italy with an Italian woman, and Italian daughters from the first marriage opposed the Somali woman's request, arguing that the Somali marriage is contrary to public order, as Islamic law admits polygamy and unilateral divorce. Hence, if the Italian judge cannot recognize the second marriage effects of the Somali marriage, the second wife cannot be considered as a co-heir. Daughter's arguments were not accepted by the Supreme Court. The court argues that the Somali marriage was perfect and valid under the Somali law. Hence, the favor matrimony principle implies that a marriage celebrated abroad in compliance with local legislation must be recognized in Italy if Italian laws on personal status and mental capacity are respected. This means if it is not contrary to public policy. In the given case, the court assumes that foreign marriage was compliant with such norms. Having ascertained her status as the wife of the Italian man, the Supreme Court concluded that Somali woman should be considered co-heir and obtain her portion of inheritance. Moreover, the court posed a clear distinction between the controversial situation and its factual assumptions. In the given case, the Somali marriage was only a precondition towards the legacy problem. In other words, in the given case, the problem was not polygamy or unilateral divorce, but exclusively the application of the inheritance Italian law. Also in this case, 2 remarks. Once again, the judicial reasoning draws on the ordre public atténué theory. This means courts don't have to establish if in general foreign legal institutions are contrary to public policy, but they have only to evaluate if the limited and specific effects of that foreign institution are in accordance with national principles and values. However, it is quite questionable the opinion of the court stating that the second polygamist marriage respected Italian laws on spouses' personal status, given that Article 86 of our civil code expressly requests freedom of status as a precondition for a valid marriage. So there's no freedom of status here. Second, apparently courts are very open to order. Even bigamy does not appear to be a barrier to cultural and juridical dialogue. However, probably a more attentive and complete analysis would show that in similar cases, the real question, which is not expressly mentioned by the court, is not bigamy, but the protection of the second wife and her children, often devoid of any both personal and financial support after the death of the husband. Third case. The facts are very simple. 2 Italian citizens of the same sex getting married in The Hague asked the Italian judge to obtain the recognition of their marriage in Italy. The reasoning of the Italian Supreme Court moves from the same principle expressed in the above-mentioned judgment. That is, a marriage celebrated abroad in compliance with local legislation must be recognized in Italy if Italian laws on personal status and mental capacity are respected. And here, we don't have problem of mental capacity or status. Moreover, the court clearly admits that neither Italian civil code nor Italian constitution expressly requests sexual diversity as a legal condition for a valid marriage. So the premise are good. However, the court argues, according to consistent Italian case law, only Italian case law, for Italian legal system, sexual diversity is a precondition of an existing marriage. In other words, Italian jurisprudence constantly requests sexual diversity not simply as a condition for validity, but as a condition for the same existence of the marriage. And the court argues this postulate is not arbitrary. It is based on very ancient shared tradition, not based on the law, but on tradition. The natural order requires that spouses sexual diversity rather than juridical, which law reflects and order. The question is not if the same-sex marriage is contrary to public policy. For the Italian judge, the same-sex marriage simply doesn't exist. If public policy becomes a door for strange or dangerous legal institution, the court invokes natural order. That said, after 6 pages, the court finally discovers European jurisprudence on same-sex marriage and quotes the European Court of Human Rights, specifically a case specifically concerning the problem of the recognition of same-sex marriage. However, in the reading of the Italian judges, the European Court of Human Rights jurisprudence merely removes any obstacle to the recognition of same-sex couples' right to marry, but the right of national parliaments to discipline such matters is not questioned, and the Italian parliament exercised that right, limiting the recognition of specific rights in specific case, not the general right of same-sex couples to marry. The consequence is that same-sex marriage exists and is valid, but, so exists and is valid, but it cannot be recognized because it doesn't produce effect. It is a strange way to I think no comments in this case. However, it could be useful to point out that Italian Parliament recently approved a law on registered partnership and civil unions. It is not exactly a marriage, but something similar. And lastly, public policy loses in this judgment. Public policy loses its traditional function of limit and is perceived as a dangerous opening to other cultural identities. Against ordre public, judges need to invoke natural order in defense of the national tradition. Two last cases, strictly connected with each other. The first case concerned an Italian couple who, in the impossibility of adopting and of resorting to artificial insemination, decided to go to Russia and agree with a surrogate mother to give birth to their child. Surrogated motherhood is expressly prohibited in Italy, where the couple is then subject to a series of trials that ultimately resulted in the child's adoption by another family. In particular, the Court of Appeal refused to recognize the foreign birth certificate as it was contrary to public policy. The Italian Supreme Court confirmed this ruling, arguing that it is certainly, I quote, "It is certainly true that public policy cannot be identified only with internal mandatory rules, but also with fundamental principles of the legal system. However, these principles cannot be limited to the perspective of the international community. In fact, international law public is the limit which protects the national order internal coherence. Hence, it cannot be reduced to values shared by the international community, but it also includes exclusively internal fundamental principles and values. Thus, public policy must be considered as a set of the internal mandatory rules and both national and supranational principles and values. Say that the Supreme Court argues that surrogate motherhood is contrary to public policy, as it is contrary to human dignity and in conflict with adoption. Exercising its discretionary power, the Italian legislator has considered that the best interest of child can be achieved through adoption, only through adoption. Such political choice cannot be questioned or influenced by judges. This was a choice of the Parliament. Moreover, even if the European Court of Human Rights affirmed that child born via surrogacy has the right to be recognized by the commissioning parents, the same European Court admitted that states have a wide discretion in the matter. Thus, the child was declared adoptable and was placed in another family. This was the reasoning of the court. In the second case, facts were very similar, so it would have been pointless to claim the Italian Supreme Court, and the commissioning parents decided to directly apply to the European Court of Human Rights. And the decision from the European Court of Human Rights was rendered in January 2015, And European Court has reproached Italy for not having properly evaluated the best interest of child, for it had ordered the child's transfer having uniquely in mind the conduct of the intended parents accused of defrauding and circumventing the surrogacy prohibition in force in Italy. The conclusion is that the Italian court should adopt a more comprehensive approach toward cases involving children, including a more reasonable understanding of the concrete issues at stake, and therefore consider that the preservation of the existing family, even if formed in violation of the surrogacy prohibition in force in Italy, might be the more suitable option for protecting the child's best interest, notwithstanding that the child was entrusted to his new family, new adoptive parents, because he had developed strong new affective family ties. This is the reason. On the one hand, it is evident the European Court of Human Rights' intention to affirm the primacy of the social dimension of family relationships over the national legal attitude of legitimizing a unique family model, and the primacy of the best interest of child over public policy. In this respect, the European Court of Human Rights clearly affirmed that the reference to public policy could not be considered as a giving carte blanche for any measure. On the other hand, it is also clear the opposition of national legislators to such point of view. Public order is the battlefield of these two different approaches. Apparently, the European Court of Human Rights accepts the traditional concept of public order as a safeguard to national policies. In practice, however, the European Court establishes a sort of hierarchy among different general clauses or different cultural attitudes, clearly stating that in balancing the competing public and private interests involved, it must have regard to the essential principle according to which, whenever the situation of a child is an issue, the best interests of that child are paramount. From this point of view, it is significant that in the examiner ruling of the European Court of Human Rights, two judges have expressed dissenting opinion, affirming the opposite principle that in this type of case, in which the national courts are faced with difficult questions whereby they must balance on the one hand the child's interests and the other the requirements of public order, the court ought to show restraint and confine itself to ensuring that the domestic court assessment is not flowered by arbitrariness. And in fact, the majority's position amounts in substance to denying the legitimacy of the state's choice not to recognize gestational surrogacy, if suffices to create illegally a link with the child abroad in order for the national authorities to be obliged to recognize the existence of family life, then it's clear that the state's freedom not to give legal effect to gestational surrogacy is reduced to none. Such judicial approach which opposes public policy to other general clauses is not convincing. In my opinion, the key point is not whether in principle a foreign judgment could be denied recognition on grounds of ordre public, but rather how the public policy exception should be understood and employed, pursuing a balance between different cultural approaches. Ordre public should not be opposed to other general clauses, but rather interpreted as a precious instrument which embodies national identities as well as international principles and fundamental rights. It should be a place where national rules, international values, and supranational imperatives meet and merge as the result of a dynamic process of osmosis between local and regional policies. Conclusion. Traditional studies on internal private law practically ignore the public policy clause. In Italy, there is a large number of studies on European public policy, constitutional law and public policy, Ordre public international, but only 2 books devoted to ordine pubblico in private law dated back to the 70s. Such disinterest could be probably explained in a context of suspicion towards interdisciplinarity. The basic idea is that ordre public concerns international relationship, conflict of law, and internal private law system is not concerned. However, my rapid analysis shows that new principles and foreign legal institutions are introduced in national legal systems, sometimes in contrast with substantive provisions. Through the public order clause, courts are slowly changing the identity of national legal system. The answer is probably positive, and this is a necessary and inexorable process in the age. The freedom of movement and the circulation of different cultural models and juridical solutions imposes a change to national legal orders, and it would be wrong for private law scholars to ignore it. Second, legal scholars usually introduce a number of distinctions regarding public policy. I said constitutional public policy, European public policy, etc., etc. However, if we agree that the public order notion expresses the corpus of mandatory rules, principles, and values of a specific legal system, it seems to me that these distinctions no longer make sense. National private law and the internal public policy clause can only be implemented taking into account both constitutional and European notion of public policy. This is a necessary consequence of the modern sources of law assessment, in which constitutional rules and European principles are necessary and structural elements of the national sources of law framework. It is relatively easy to share this conclusion with reference to the relationship among internal, constitutional, European levels. But what about the relationship between internal public order and international public order? As I said, these two notions seem to have different functions and different areas of implementation. However, if we consider the impact of the use of the internal public order on the interpretation of the internal law and the role of human rights in this process, the above-mentioned difference could become more nuanced. The modern sources of law theory imposes an obligation on the judge to implement a multi-level notion of public order, and several judges are conscious of their difficult task in a growing number of cases. This means to adopt a unique notion of public order as, I quote from a sentence, the set of fundamental values and principles historically shaping the legal national order, having the unique function of selecting acts of private autonomy and foreign judgments and foreign laws, which can be accepted in a given legal order as they are not contrary to its axiological identity. Furthermore, the idea that public policy is a comprehensive notion, not limited to the national dimension, is not new among legal scholars, and the opinions start to be shared that private juridical relationship must be settled in the light of both internal and external values, were acceptable as a common heritage of a given supranational juridical community. Third, public policy has traditionally been understood as a limit, drawing the national system borders. It was aimed to protect the legislator's political project against any possible interferences of private autonomy and to identify the set of mandatory rules, principles and values characterize a given legal system against any possible trespassing of foreign institution. In other words, public order was the mirror of a strong legal and cultural identity and at the same time the tool to save and protect this identity. Such reading no longer corresponds to the public policy current functioning. It is rather often perceived and or used as a door through which foreign legal institution can get inside the national legal system concerned, even when that foreign institutions are not in accordance with the internal legal discipline. Faced with the increasing frequency of cultural conflicts, the legal answer cannot remain the defense of the established order. Public policy is not, by its nature, a hard-edged concept. As such, it may help national authorities in weighing different considerations one against the other and accommodating the different needs connected to the situation at stake. Seeing this light, the ordre public becomes a search for harmony very far from its traditional restrictive semblance. The key issue in all examined cases was precisely whether the public policy exception had been properly resorted to as a ground for denying the recognition of foreign legal institutions. In the age of globalization, its structural vagueness could become a strategic asset, playing a key role in the necessary process of axiological approximation among different legal systems. And last, using public policy, judges make decisions allowing to manage modern cultural conflicts. They produce law, even in civil law countries, when legal solutions are not sufficient, whether the solution is not codified or the codified solution is no longer useful. By this way, national legal orders let foreign institutions in to fill a void spaces where the political choice is not defined or not convenient or not sufficient. When the legislator cannot or will not find a positive solution for juridical problems, it delegates to the judge its proper normative function. The first conclusion is obvious, a new sources of law structure. And the second remark is that, in my opinion, the traditional judicial approach was strongly consistent with the political attitude of the legislator, while the new trend is a growing distance between legal and judicial choices. Such trend is particularly striking when the legal solution requests a strong political choice. That is when legislator is faced with strong cultural conflicts and it doesn't want to pay the relating consequences, fearing, for example, not to be re-elected. See for Italy the case of the child adoption. In that cases, the political power seems to prefer to delegate its own role to judicial courts. However, what about the judicial responsibility for political choices? Who is the responsible? After all, probably we have to return to the eternal question of the judicial power, but the risk is going too far, and probably I'm not brave enough.
Well.